the standard has of us. We'll also, at the end, if we have time, look at the record keeping versus what actual documentation is, because record keeping is really just the first step, and it's not everything that employer must deal with. And we'll try to get to some OSHA updates that are happening around the OSHA, the country, dealing with OSHA, and what this really means for employers like yourself. So without any further ado, let's dive right on in. This typically takes, when I do this class, about an hour and a half to 2 hours. We don't have that much time. We're going to try to get this through within about 45 minutes, no longer than an hour. So if you do have questions, save them to the end, and we'll definitely get to them at that point. But again, what is the purpose of this standard? I like to discuss what it really is not. It is not in any way, shape, or form mean that an employee or employer is at fault. There's a lot of misunderstanding in regards to this because the law was set up to be a no-fault record-keeping system. There's a lot of underreporting right now because of the misunderstanding of what this standard is for. It does not mean employees at fault. It does not mean the employers at fault. It does not mean that you're going to get a fine or penalty or receive any type of violation. And it definitely does not mean that just because someone has a recordable injury that it's eligible for workers' comp or any other insurance benefit. So what is the purpose of this standard? It's quite simply a requirement for employers to record and report work-related fatalities, injuries, and illnesses. And I would recommend everybody listening today to visit the OSHA.gov website, be acquainted with that. It's a lot of resources on there, but if you actually will Google on that site or search on that site for a July 19th, 2010 letter by Assistant Secretary Michaels, you will find a letter called OSHA at 40. OSHA is 40 years old now, and they've got some specific goals in that letter of what they're trying to accomplish. Well, record keeping is one of those. And in that letter by Secretary Michaels, he specifically states that effective safety programs rely on accurate reporting. He goes on to detail that reports and patterns of current workplace injuries and illnesses are an important tool in preventing future injuries or illnesses. So really, the 1904 standard is just one step of a comprehensive program that you must implement. So what we're going to look at the end of this Smartcast is how are you using this info? How are you using this information gathered in this standard, and what are you doing about these injuries? And we'll talk about that a little bit later. But now that you know the purpose of the standard, let's actually look at, I'm having some difficulty here with the slide, but we need to know who must comply. If you have less than 11 employees and you're not specifically exempt, then you have to comply with this standard. So if you are an exempt, you'll know because there's a list on the OSHA website. If you go to, again, OSHA.gov, Appendix A of partially exempt industries will list all of those various businesses. And I'll give you kind of a quick review of some of those. Hardware stores, used car dealerships don't have to report these incidents, gasoline stations, motorcycle dealerships. You've got legal services, engineering, accounting firms, insurance companies don't need to report. Medical offices don't need to report. And the thing to look at here is that you need to look at the primary SIC code of the business. And if the primary SIC code that they're involved with is on this list, they don't need to comply. So car dealerships that might have a body shop as part of their business does not need to comply. But if you have a body shop and that is your primary business, then you will need to comply. Medical offices, this has definitely created some confusion for medical offices out there. You do not need to comply with the 1904 record-keeping standard. However, you do need to comply with the blood-borne pathogen standard. So all needle stick injuries must be logged, but they do not need to be logged on an OSHA form, the 300 form. You just need to keep a separate log of those needle stick injuries. What are the reporting requirements? Now that you know that you are a covered employer, let's look at what those reporting requirements are. And quite simply, we must know, is it work-related? Is it a new case, and does it meet some of the criteria contained in the standard 1904.7 through 1904.11? And we're going to go through these step by step to give you a better understanding if this injury or illness is recordable. What we've got is a very simple flow chart to help you with this, and you'll see if everything is marked yes, then you have to record. You might be familiar with OSHATracker from the Future Office. This is a program that helps you enter in these recordable accidents, and you'll recognize some of these questions on that program. Step one, did the employee experience an injury or an illness? This is going to be pretty self-evident, pretty obvious. If there's any type of abnormal condition, any type of abnormal disorder that an employee that happens at the workplace, it's not limited to a cut, it's not limited to a bruise or a rash. If they have a fracture or a sprain or an amputation, those are more obvious. But anything that's abnormal that happens that creates a condition or disorder, it is an injury or illness. Now, step two is it work-related? This is the more confusing part of the standard in trying to determine what is work-related and what is the actual work environment. And it's really presumed by OSHA that anything that happens in the work environment or anything that's work-related is going to be recordable. And a case is presumed work-related if and only if an event or an exposure in the work environment is a discernible cause of the injury or illness. This does include things that include pre-existing conditions, if there's a significant aggravation to something that's already happened in the past. Let's dig into work environment and work-related type of injuries or type of environments. I've got this broken down into two sections. Work environment on the left, work-related on the right. And this has caused a great deal of confusion out there. Now remember, this is a no-fault record-keeping system. If you actually record something that really is found out later that is not work-related, you're not going to get penalized. If you underreport, that's when you're going to have fines, penalties, and trouble with the OSHA enforcement agencies. So again, if there's any doubt, don't hesitate to record. Let's look at parking lots. Any type of commuting back and forth to work is not going to be recordable. Now, it's commuting to and from work. It's not doing work-related activities like going to the post office. Those would be recordable. But if you are commuting to work, have an accident, it's not recordable. But once you drive into that parking lot and park the car, and if you were to get out of that car and trip, even on your own car, onto the parking lot, it would be recordable. If you're walking from the parking lot to the clock-in station and you slip on ice, it would be recordable. So what OSHA is going to look at is not so much clocking in and out as a determination for work-relatedness. It's going to be looking at the work environment and the assigned working hours. So if they're walking from the parking lot to work and they get injured, it's going to be recordable. Let's look at travel status. If a person is having to travel maybe to Vegas for a convention, to a sales seminar, or any type of training outside of the normal work environment, then it all depends on how the injury occurs. Once they check into a hotel, it's assumed that that is now their home environment for that stay. Now, however, if they are going to a convention, if they're in meetings in that hotel or doing training within that hotel for work-related purposes and they get injured, it would be considered recordable. If you're now considering that your home base for the purpose of the trip and now you're commuting to a specific site and you get injured while in commute to that specific site, it would not be recordable at all. However, once you get to that site and you perform those work-related duties and get injured, it would be recordable. Telecommuting, we've got a lot of people now working from home as a way to cut costs. And if that person in that home environment gets injured in that office, but if they're performing those work-related duties, such as lifting a box of of documents and it drops on their foot, that would be recordable. However, if they're running to the kitchen, they trip over the dog, it would not. Putt-putt. This could be considered a work environment depending on the circumstances. If you have a mandatory team building or leadership exercise at a putt-putt or any other type of facility, and it's mandatory, then it would be recordable if someone gets injured. Now, if it's a voluntary employee event and you don't have to show up and employees are there having a good time, and again, it's voluntary only, and they get injured, it would not have to be recordable. Food and drink, on the right-hand side, we need to determine if it's work-related. So food and drink typically would not be considered work-related. If they're consuming food bought by the employer through a drink machine or a food machine, it would not. Now, however, if the employer offers food, maybe through a picnic that the employer's having, and food poisoning occurs, then that would be recordable, but only if the employee suffers food poisoning. If it's an allergic reaction, you don't need to record. Personal grooming, any type of combing of hair, brushing of teeth, anything like that would not be considered work-related. Same with flu or cold, any type of personal tasks in the work environment, but this can cause confusion. Personal tasks like going out and smoking outside the employer's office on premises would not be considered a personal task that would be excluded from record keeping. So if they're smoking, they get injured on premises, that would be recordable. Now, if they are coming in on a Saturday or early in the morning for a civic meeting, we have a business here in town that has safety meetings every first Tuesday of the month. If that employee who puts on that event gets injured, that would not be recordable because that is not work-related. That would be a personal task. If that employee comes on premises as a member of the general public, say on a Saturday or any other time, not during their regular assigned work hours, then that would not be recordable as well. Wellness programs, a lot of employers now are trying to curb the cost of health care, and they're putting in exercise rooms, they're implementing yoga classes, and if these employees get injured due to any of these type of wellness programs, it's not recordable so long as that it's voluntary. Again, we've already mentioned team building, and mental illness is typically never recordable unless the mental illness is decided to be from a work-related event or exposure. Let's go into step number 3. Is the injury or illness a new case? You can pretty much just assume that anything that the employer has an injury on that was not previously experienced, whether it was the same type of body parts, it didn't affect the same area. If that person has a brand new case, then it's going to be recorded. But if a person has an injury and now they are completely healed and now they just re-aggravated that, it's a new event, then that new event would cause a new case. But this is where a lot of times you have to rely on your physician or a licensed healthcare provider to give you that guidance to say, is it a new case or is this just a flare-up of an already existing case? So lean on those healthcare providers to give you direction here. If there's any type of ambiguity and you're not sure, again, just go ahead and add a new recordable injury, and you can always change it if you get new information. New case scenarios, again, if a medical opinion is rendered by a healthcare provider, then you always must follow that opinion. Again, if you have an exposure that triggers the reoccurrence, it is a new case. So if you have chemicals in your business and that causes a new flare-up of asthma or a new flare-up of rashes, that is a new case. But if you have a person that contracts cancer or some other type of problem in the workplace, that it's now just a recurrence of the same exposure, then it's not a new case to record. Step 4, does the injury or illness meet any of the general criteria of the application to a specific case? So we've kind of gone through, is it a medical injury? Is it an injury or illness? Is it work-related? Is it happening in the work environment? And we really need to understand from this point on, are there other things that are going to cause this to be recordable? And we need to look at the general recording criteria. Anything that deals in death must be recordable. Any days away from work must be recordable due to that injury that occurs in the workplace. Any restricted work activity or transfer, any type of medical treatment beyond first aid, and the other two items that are listed there. But what we're going to do is dig into these just a little bit more to give a better understanding of what these mean and what you need to do. Death is pretty obvious, so we'll go right to days away cases. If you have a healthcare professional that recommends that an employee must stay out of work for a day or two, then you must record that injury and follow their opinion. Now, you do not need to include the day of the injury. So if an injury occurs on a Friday and the doctor says that the employee needs to stay out for 7 days, then you only need to include the 7 days recommended by the healthcare professional and not the day that the injury occurred, which would be Friday. Now, to count the days necessary on the form, you will include all calendar days. That will include any type of vacation that was already scheduled, weekends, holidays, etc. So again, if an employee is injured on a Friday, the healthcare professional says the employee needs to be out 7 days, you would not subtract the Saturday and Sunday from that number. You would put the full 7 days on the form. If you have a major incident or exposure, you would cap the number of days at 180. And you can actually stop the count once the employee leaves the company for any other reason than the injury or illness itself. So if you have a person that is deemed to be disabled, permanently disabled, again, you would keep counting until that 180-day cap is reached. Restricted or job transfer cases, any type of injury that would cause the employee not able to perform the full workday that he or she would otherwise have been scheduled to work, or they are not able to perform one or more of their routine job functions, then you need to record that underneath that restricted or job transfer area of the form. Now, how are you going to know if a person is not able to perform their routine job functions? Well, OSHA says that employees' routine job functions are those activities the employee regularly performs at least once per week. You might be familiar with the human resource Smartcast that Craig Davidson has performed over the last couple of years, and there is one on job descriptions. Job descriptions easily breaks down an employee's job functions into essential and non-essential. These essential functions are the routine job functions. So having job descriptions are very important to determine whether or not this is restricted. Medical treatment. If a person is under the care of a physician and that illness or injury is being managed to combat that disease or disorder or to make them better, then that would be considered medical treatment and thus recordable. Now, however, if you have an injury, say on that same Friday at 7 o'clock a.m., and they're just very worried that that injury could have led to something more severe, say it's a car accident on the way to perform some work-related duties, and they're shooken up, and they just want to make sure that everything's okay, and thus they have MRIs or X-rays, and they just have these diagnostic procedures. If everything is deemed to be okay and no medical treatment is offered, then it is not recordable. Anything that's first aid, they just stitched them, that they just band-aided them up, they just washed the wound, it would not be considered recordable. We're going to dig into this just a little bit more because first aid can be confusing for a lot of people. What I would just understand that this list right here is the comprehensive list. There is no other items considered first aid. If it's not on this list, it's not considered first aid. So you don't see chiropractors on here. That's not considered first aid. You're not going to see, you will see tetanus immunizations, but if you get a hepatitis shot, that would be considered getting medical treatment. Getting hot or cold therapy, wound coverings. If you're using liquid wound coverings, that's going to be the same thing because it's just covering the wound, and it's not considered medical care. Drinking fluids for relief of heat stress, all of these things here is a comprehensive list, and there's nothing else to consider in first aid. Loss of consciousness. pretty self-explanatory here. Any type of injury that leads to a loss of consciousness must be recorded. Any type of significant injury or illness that's going to be diagnosed by that healthcare provider, like cancer, a punctured eardrum, a fractured bone, any type of irreversible disease must be recorded. Now, once you understand what you must record, now let's dive into the forms that you must use. OSHA has, again, a wonderful packet that you can use. If you go to OSHA.gov, they've got a PDF form that you can download that's going to include all the forms plus all the instructions that you need in order to properly place the information on these forms. But the 300 log is that log that you're going to use to record all of those injuries. The 301 incident report is going to be that more detailed report that's going to give the time and more specifics about how the injuries occurred. You don't have to use the forms that are provided by OSHA. If you're familiar with Future Office and you know that there's a specific program on there called OSHATracker, you can use the OSHATracker that will help you determine a work-related incident, if it's recordable or not, and then combine all of the forms in the one, including the first report of injury for workers' comp. Makes your job a lot easier, and that is a compliant form to use. So that, as long as it has all of the information that OSHA requires, you can use any form that you want. If you have an Excel spreadsheet or any other type of vendor out there that sells an electronic format, as long as it has all of the information and it's readily available, readable, and understandable, then it can be used. Once you have that injury or illness, just make sure that these forms are filled out within 7 business days of receiving the information. Typically, employers like yourself are already used to getting these first report of injury forms out for workers' compensation in a timely manner. Just put this as part of your process to fill out the 300 and the 301 at the same time. Your workers' compensation carrier is not responsible for the OSHA reporting, so they typically will not do those forms for you. These forms can be kept on a computer, so long as that they can be reproduced in a timely manner, and we'll get to that part of the standard in just a couple of slides. Here's just a brief picture of the 300 log. You'll see the 300 summary and, of course, the 301 incident report, just to show you a quick picture so you'll know what you're looking for when you go on the OSHA website. Now, when you're filling out these forms, you do have the ability to protect the privacy of certain individuals. You can enter, instead of their name, privacy case in that name column. Now, you would want to do this for a number of reasons. If an employee has a injury or illness to an intimate body part or reproductive system, maybe a sexual assault that occurred on the premises, any type of blood-borne pathogen contamination, HIV as an example, or hepatitis, these people that are exposed to those illnesses do not want that information, and it must be protected so others don't discriminate against them for having that, that injury. Needle sticks as well, and any type of instance where an employee is going to come to you on a voluntary basis and say, please keep my name off that list. You can do so, but just make sure that all of the information regarding that case is in a separate file in your HR department. Now, the key thing here with keeping separate documents to correspond to that privacy case, it must be accessed only by key individuals. It needs to be in a locked file. It should not be in the employee file. It should be in a separate file that might have other workers' compensation information in it. It might have reasonable accommodation requests under the ADA will be in that file. It might be health insurance information, and the questions on an application would be all in that separate file to protect health information of that employee, and it must be locked, and only certain individuals should have access to that. Only first responders, safety personnel that need that information, maybe to help with evacuations or safety instances, and, of course, top management. Not every manager or supervisor should have that information for other discriminatory issues that could result. Exceptions to the people who should have access to it, like I said, are first responders, any type of auditor or consultant like myself that will be coming in to help, workers' compensation or other insurance personnel, or anybody from the public health authority or law enforcement agency will need that. Now, looking at multiple business establishments, we know a lot of employers out there have multiple locations, and so long as that each location is expected to be in operation for more than a year, then you would have a different OSHA Form 300 log at each location. If it's not going to be there for more than a year, then you can keep one log so that it's linked. It can be at maybe headquarters, but it's got to be linked to those establishments. Each employee must be linked to that form. What employees must be linked to these forms? Well, if you have employees that are on your payroll, then all of those employees, if they were to become injured, are going to be covered employees. Any employees that are not on your payroll, you might have an independent contractor that's not W-2'd, but 1099. If they are under your day-to-day supervision and they get injured, then they would need to be on those forms if a recordable injury occurs. You don't need to include any self-employed or partners. Now, if there's a CEO, CFO, any type of executive would be covered. They are considered employees under that corporate structure. If you have employees that are gathered through temporary employment agencies, then this can be a little bit tricky. Again, if they are under your day-to-day supervision, they would need to be recorded underneath that firm's forms, not the temporary help agency. Now, if the temporary help agency is responsible for those day-to-day duties, and I'll kind of explain this in a little bit more detail, these are day-to-day supervision generally exists when the employer supervises not only the output, product, or result to be accomplished by the person's work, but also the details, the means, the methods, and the processes by which the work objective is accomplished. So if that is being done by your employer, then they have to record those injuries by those temporary help. But the key thing here is there only needs to be one form. OSHA does not want your employer's agency to do it and the temp agency to do it. Only one form. Once all of these forms are properly filled out throughout the year, there needs to be a posting of the 300A summary form so that the employees can understand the type of injuries that are occurring at the workplace. A person needs to review this form for completeness. If you find mistakes, items that need to be updated, do so at this time. And then someone in their firm must certify it, but it cannot be just anyone. We have a firm here in town that has about 4,500 employees in dozens of locations across not only Lynchburg, but across the state. And they had someone in their HR department that was certifying these forms. That is actually, they are non-compliance of the 1904 standard because only the owner of the company can sign and the officer of the corporation can sign. The highest ranking company official at that work establishment, so if you have a separate location, the highest ranking official at that location can sign, or that person's supervisor. This HR person did not supervise anyone, so that person cannot sign. Only these people here. Once that's certified, it must be posted, and it must be posted starting as of February 1st and done so through April 30th of the following year covered by the summary. Let's look at retention and updating. Now that you've got these forms, you must keep these forms in your filing system for a minimum of 5 years. If you're using the Future Office OSHATracker program, that's going to do that automatically. You can use it. You can do that digitally. You can do it in paper form. You just must be sure that it can be accessed and readily available in the time limits required by OSHA, and we'll get to that in just a second. You do not need to update any other form except the OSHA 300 during that 5-year period. So if you find some discrepancies, you find some errors, you only need to go back and update that 300 log. Employee involvement. Now this is a key part of the 1904 standard. you must include your employees. You must involve them in the record-keeping process. More specifically, you must inform each employee of how to report an injury or illness. Typically, if you have a new employee orientation process, this would be that time where you want to make sure employees understand what they need to do as part of that company's policy or procedure. If you have new employees and you haven't done the training in a while, this is something you definitely want to look at least once a year to make sure the employees are involved in doing this properly. You must provide limited access to these illness records to employees or any former employees. And there's some guidelines there. Basically, by the end of the next business day for that employee or personal formal employee, and if it's an authorized representative, maybe if you're dealing with unions in your area, a union representative wants to get access, then you have 7 days to give that information to that authorized representative. Fatalities and catastrophe reporting. If you do have a death on premises, this is very difficult. The last thing that you're really thinking of at the time of a death or a major event where 3 or more employees are injured or hospitalized, I should say, the last thing you're thinking about is calling OSHA. But there's been a lot of fines in this area because OSHA wasn't properly notified within 8 hours of that fatality or incident involving 3 or more hospitalizations. We had an incident where a owner was working after hours on a printing press, got sucked into it, and died. The family, who they all worked in the business, the last thing they were thinking about was calling OSHA, and they actually got a $70,000 fine because they did not. Well, actually, it wasn't $70,000, but it was a very, very high amount because they did not call OSHA. Now, you do not need to report a fatality or a major injury if it is due to a highway or public street motor vehicle accident. Now, you don't need to report the fatality, but you do need to log it in your 300 log and do an incident report. What OSHA is thinking here is that because it's going to happen on a public street, you're going to get the police department, the Department of Transportation is going to get involved, and they're going to do an in-depth study of what happened and how to prevent it in the future. OSHA doesn't need to get involved. Same thing with a commercial airplane or a commercial train or subway incident. There's going to be another government agency that's going to get involved, and you'll need to report that fatality or incident with OSHA. Any type of government representative, like an OSHA enforcement officer, if they were to come to your business and require to see your records, your record-keeping forms, then they have 4 hours to get it. And it must be, the timing must be based on the time zone in which the business is located. Even though the home office where the records are kept electronically might be in California, if they come to you in Virginia at 8 o'clock in the morning, you've got 4 hours from the Virginia time zone, not waiting for California to get up and running. Let's look at record keeping versus documentation. Now that we know what we must do in order to record an injury or illness, what does that really mean? This is not documentation. This is just the reporting and recording of health-related incidents and illnesses. It is not proof of life. It does not mean that you have an effective safety program. Documentation is that proof of life that you have a robust and employee-oriented safety program. So if you have this down pat, and now that you're recording an injury, what are the next steps that you must take? Well, the next step you must take is you must do an accident investigation. The whole key of finding out whether or not something is recordable is how do we prevent this from happening again? This is a work-related incident or illness. We need to do a full-blown accident investigation. This is not going to be done by your workers' compensation. You cannot put this off on a workers' compensation representative from the carrier, because all they're looking at is from their point of view of lowering workers' comp costs. We care about that, but OSHA cares about preventing this from happening again. Once you have a full-blown accident investigation done, you need to look at how do you prevent this accident from occurring? Is there a way to eliminate this from happening again? Is there a policy or procedure we can put in place to prevent this from happening again? Is there any type of training that we can do to prevent this? And each step of this, each step that you take in this effort must be documented. We have a lot of firms that we go into and we do inspections. We look at their training, we look at their organization, and look at the various aspects of safety. And we find out they're doing a lot of wonderful things, but they're lacking the documentation. If OSHA were to come in there, if you don't document it, in their eyes, it did not happen. So if you do get a fine or a penalty, the documentation will give them proof of life and a safety program exists, and it will help you reduce the fines and penalties that you receive up to 60 to 70%. That documentation is vital for a lot of different reasons. Giving you an update, a quick update, since we're running, actually we're running right on time here, give you an update on the various OSHA programs that are available right now for record keeping. In 2009, OSHA started their emphasis program. And what OSHA found out is that a lot of the injuries and illnesses that are occurring in the workplace are not being properly reported. Their findings are about 50% of the illnesses and injuries that are occurring in the workplace are not being recorded. So they started an emphasis program to really kind of come down on employers to force them to see the importance of doing so. And with this emphasis program, they have added a lot of fines, a lot of citations to employers who are consistently not reporting injuries. And one of the things I really want businesses to focus on here is the incentive and bonus programs that you may have that could be discouraging the reporting of injuries. You have businesses out there that will give maybe gift cards. They might have pizza parties or other types of incentives for those work sites that have not a lot of injuries, so they don't experience a lot of work-related accidents. Well, by providing that incentive, employees are going to be very upset when another employee reports an injury, if it's recordable. So certain employees might not turn in that injury, keep it to themselves, or other employees will discourage their other fellow employees from doing so because they're not going to lose that benefit or incentive or bonus in their paycheck by doing so. What OSHA wants businesses to focus on is not the negative aspect of incentive by looking at the positive. What are they doing positively? And let's give a bonus or an incentive based on that positive behavior. They are looking at training. They're participating in training programs. That's positive. They're helping on a safety committee. That's a positive behavior that we want to reinforce. Giving an incentive for that would be okay. Incentives for turning in hazard identification forms or sheets. If they identify exposures in the workplace and they're bringing those to their employers so that they can deal with that, or that safety committee can then appropriately respond, that's a positive behavior that OSHA wants to see. And actually, with the various VPP programs out there, these are programs set out by OSHA to really reward those employers that meet certain milestones. You will lose that VPP status under OSHA if you are seen to have incentives or bonuses that discourage accurate reporting. This OSHA program, this emphasis program, is targeted high-hazard industries. They have, in the last couple of years, have expanded that to other industries, and OSHA has really obtained a lot of fines and a lot of citations for this. One of the things that OSHA will do when they come in is look at your OSHA record keeping. It's not as severe as it was here last year or the year before. They're kind of calming down a little bit on this. At least in Virginia, and talking with the key people in OSHA here in this state, it's not as bad, but they will be looking at those record-keeping documents to get an idea of the type of injuries that you have and seeing if you're doing anything about it. But just be aware also the updates that OSHA is looking at. OSHA is looking at changing this standard, and need to look at those changes and how it's going to affect your business. The exempt list is going to expand. They're actually going to take some off the list. I'll give you a clear example here. If you are a dealership right now, you technically do not need to follow the 1904 record-keeping standard. Under the proposed changes, though, dealerships would need to follow this standard. They are also looking at expanding the reporting requirements, that if you have an amputation in the workplace right now, you do not need to call the OSHA office. However, if this change were to go through, you would need to call OSHA within a 24-hour period to let them know that an amputation has occurred. And right now, you do not, let's see, right now, if you have 3 or more individuals that are hospitalized, you need to report that. But in the future, if they get their way and make this change, then all inpatient hospitalizations will need to be called into the OSHA office within that 8-hour period. Those are some of the changes that are occurring. Now, right now, I definitely want to open this up to any questions that there might be. We've gone through a lot of information here in the 45 minutes. I've tried to keep it short. I did gloss over, actually didn't even go over some of the other requirements under the criteria, the reporting criteria. Geez, I can't talk. I did not go over other reporting criteria such as bloodborne pathogen. That's 1904.8. I did not go over medical removal, hearing loss, or tuberculosis. Those are all things that require a lot more information to properly understand, so I would recommend all of you to look at that if you have a hearing loss or bloodborne pathogen exposure. So we'll open it up at this point to questions.
All right, John, we have a couple of questions. Judith Lovelace, I'm going to turn on your phone. Judy, are you there?
Yes, sir.
You still have a question?
No, I didn't have any questions.
Oh, you raised your hand. I'm sorry. Okay, we have, let's see here. Jean Heinzman, you raised your hand. Jean, can you hear us?
Yes, I can.
You have a question?
I'm not sure if this was covered previously. Is there a way to get a quick PowerPoint copy of your presentation following?
Absolutely.
So I can make notes on?
Sure.
Absolutely.
The actually they were all sent out last week, and
okay.
You can also go on to Feature Office Network and go under Smartcasts, and you'll see the PowerPoint presentation that John is presenting. The exact same.
And she brings up a good question there, because there is something else that the participants can get access to. If you have access to the Future Office Network and go under the Employee Training tab, there will be underneath the 1904 record keeping part a quiz that you can take with the answers. It will go through everything that we went through here today and kind of get an understanding of your retention of this, but have it really for future instances where you need to look back and find the information that you need. And actually, that quiz is taken directly from the 1904 standard, and a lot of times I use that as part of a safety talk to employees or to a group of managers that need to know what the standard includes. So if you don't have access to Future Office, just email Future Office at support@yourfutureoffice.com, and we'll make sure that that quiz with the answers gets out to you.
We'll take care of that, Gene. Thank you for the question. We have a question here from, let me get down to it. Also, if you don't want to raise your hand, you can write in the questions, folks, where it is done. It says questions. You can just write them in. Be anonymous. Okay, Shannon Fish Fertitta. Did I get that right, Shannon?
Yes.
Hope I didn't mess up your name. Oh, good.
No.
I got lucky
Perfect.
once in my life.
Yeah.
Shannon, you had a question?
I do. This could be something that you did graze over that maybe I missed. On the OSHA reporting for first aid, I'm the first aider, so I just am curious the type of things that you need to report on those 300 forms. Paper cuts, I mean, it does require first aid. They have to come to me and get Band-Aids.
Yep, that would not be recordable. So if they come to you as that on-site, say, nurse or first responder, and they only get a Band-Aid put on, then they're fine. You don't need to record that on your OSHA 300 log.
Okay, but so the difference just really is if something occurs in the warehouse and they have to seek medical treatment.
That's correct. You know, they're bleeding, and it now requires not just a bandage to keep the blood going, but they need stitches. That once they get stitches, then that incident would need to be recordable.
So in other words, beyond what my first aid can do, if it goes beyond what I do, if it has to be treated outside of our office.
Correct.
Okay, great. Well, that clears it up for me.
No problem. Glad to help.
Thanks so much.
All right, thank you, Shannon. And then we have a question here from Mike Sanson. Mike, go ahead with your question.
Yeah, can you hear me?
Yep, we sure can, bud.
Okay, we're OSHA and MSHA governed here. Is an MSHA recordable accident required to be reported on our OSHA logs?
I am not trained in MSHA. That's a whole other area of training, and that's a beast because they definitely can come down hard on you there. I would think that anything that's recordable in the 1904 is going to be recordable for MSHA. I'm just not familiar with the MSHA law or standards, so I can't give you guidance on that. But we do have someone on our team that knows MSHA very, very well. So what we'll do is we'll go back and get that question answered for you.
Okay, and then also I turned in a quarterly report to MSHA. Are there hours recorded on OSHA, or do we combine those hours, or do we have to keep those separate?
Yeah, anything dealing with OSHA, anything dealing with MSHA, I'm not going to be able to provide any accurate advice on. Again, that's a whole other area of training that I've stayed away from. But I just don't have any customers in the area that deal with quarries.
Okay.
John, would that be Frank?
Yeah, Frank would have experience with that, and we also have another person on our team, Stuart, that would have experience with that too. So what I would recommend is email those detailed questions to support@yourfutureoffice.com, and we can get that information out to you.
Okay, I appreciate that.
Yeah, MSHA is a whole nother beast, and it's very, very complicated, and it's dealing with the hazards that are in that environment. It's something that I would rather stay away from to make sure I give you the right advice.
Okay. Okay.
Thank you. Thank you, Mike. And then we have some written questions. Let me read them off for you, John. Let me get down here. You just covered my question. Well, that's a good thing. What are some examples of acceptable incentive bonus programs for workplace safety? We have 2 offices handling workers' comp. Can we keep 2 sets of form? Hang on a second here. We have 2 sets of form. Thank you for all this information, but I have an on-site job meeting to attend. Okay, so, well, for the benefit of everybody else, maybe you can answer the question.
Yeah, the incentives or bonuses, again, it needs to be something that's going to create positive behavior, a behavior that OSHA really wants to see and would really determine whether or not a company has an effective safety program. And one of the key components of an effective safety program is having employee involvement. If your employees are not involved, it's impossible to complete to have a safe work environment, or at least to have a really, really 100% safe and work environment. No such thing as 100%, but 99% would be great. So if you're going to have those incentives, let's have an incentive for people that turn in hazards in the workplace. So you have a box in your plant, and you've got a form that people are educated on and they know how to fill out, and this form is all geared to employees filling out the form to report injuries or hazards, I should say. And at the end of the month, you reach in that box and you pull out a form, and an employee his name is on that, and you would give a series of gift certificates or rewards for that notification of a work-related hazard. You want to promote the behavior that you want. You don't want to knock down an employee because they let the employer know of a work-related incident. It might be annoying, it might be costly, but the employee is just trying to help keep the place safe. So let's reward that positive behavior. You might have a lunch for, if you have 100% participation in a certain department or certain plant, you might give a party, a cookout, some type of event to reward those employees for everybody participating in some type of training exercise, whether it's a safety talk, whether it's video, whether it's going to a 10-hour class. But if you get 100% participation, or you get some type of majority of those employees participating in some type of training program, you would give some type of bonus, some type of benefit. Those are two examples.
All right, two more quick questions here, John. Please confirm when you refer to dealerships that you are referring to auto dealers. We have several auto dealer clients, and since there is a shop at each location, and they have had injuries each year, we have always had them post the 300. Is this necessary?
Let me see if it's all going to be based on SIC code, and it specifically says auto dealerships and also motorcycle dealerships. So I would encourage you to go to the OSHA website and get the exclusive list of everything that is partially exempt. And what it says here is new and used car dealerships, and it's using the SIC code 551. This would also include used car dealerships under the SIC code 552. Motorcycle dealerships would be under that 557. Again, posting it, you're not doing anything wrong. You're not going to get penalized for doing it. They just don't have to go through the extra steps of following this 1904 standard. They still have to comply with all the other laws. They just don't need to do the reporting. And really, the posting of that 300A is supposed to be there for those employees to let them know of the various illnesses and injuries that are occurring on the at the workplace. So these are the things that you need to focus on, because these are the injuries we know that are occurring at this workplace. And it's a great part to add to any type of new employee training orientation.
Okay, one more question, and then we'll call it a morning. It is my understanding that the first aid can include X-rays if used only as an assessment. Is this correct?
Absolutely. Yep.
Okay, and then there's a second part. Is there just for employees? And it says, I work with a private college, and we have had students injured that I report to my insurance. Does this have to be reported to OSHA, or is it just for employees?
Yeah, it's a great question, and that's where there's a lot of confusion in dealing with OSHA. OSHA is the federal law dealing with employee safety. So anything dealing with your clients, dealing with students in this particular situation, OSHA is not going to have any authority over it. Now, your insurance company might be providing liability coverage, bodily injury and property damage coverage for those individuals that aren't employees to have a way of getting their injuries covered or paid for. But that has nothing to do with OSHA.
All right, there were a few more questions, but in the interest of time, I know we always say we're going to keep it under 1 hour, and we're just about there. So we're going to conclude, and please fill out the evaluations. There was a question on here that I can easily answer, and that is this going to be recorded? And the answer is yes, it has been recorded. And perhaps later on today, if you go on to Future Office Network and you go under the Smartcast tab, you will see that John's presentation will be featured there, and you can watch the slides, listen to anything that you might have missed or a little too fast or whatever it might be. But we want to thank you all, John and I, for participating on this Smartcast. And if you like this angle, please, with featuring different speakers on different topics in commercial insurance and other areas, please let us know on the evaluations as well. Any feedback we can get would be appreciated. John, I want to thank you for participating on our Smartcast this morning, and thank our audience for participating and letting us bend your ear for about 50 minutes or so this morning. Thank you, everybody, and have yourself a good day.